Hello and welcome to episode 3 of the Parliament Podcast. I am your host, Andy Segadin, online managing editor of Temple Law Review Volume 91. Before we introduce today's guest, I'd like to very briefly plug our upcoming symposium titled Taxpayer Rights in the United States, All the Angles. That will be taking place on Friday, October 26th here in Klein Hall at 1719 North Broad Street. I know that my colleagues have worked very hard on this, and we hope that you attend. Now on to today's episode. We are very excited to welcome our first former editor-in-chief to appear on the podcast, Stefanie Lindquist. Professor Lindquist is currently Deputy Provost and Vice President of Academic Affairs at Arizona State University. Prior stops include Arch-Professor and Dean of the University of Georgia's School of Public and International Affairs, Interim Dean, Associate Dean for Research, and Associate Dean for Academic Affairs at the University of Texas Law School, and Associate Professor of Law and Political Science at Vanderbilt University. Professor Lindquist is a noted authority on the United States Supreme Court and has written a book on judicial activism. We are thus very excited to speak with her about the nomination of Judge Brett Kavanaugh, and we hope that you enjoy. Thank you.
We are very excited to welcome Professor Stefanie Lindquist to the Parliament Podcast today. Professor Lindquist is Deputy Provost and Vice President of Academic Affairs at Arizona State University. She serves as Foundation Professor of Law and Political Science as well. She holds a PhD in Political Science and Public Administration from the University of South Carolina and earned her JD here at Temple while she served as Editor-in-Chief of Temple Law Review Volume 61. Today we'll be talking about the nomination of Judge Brett Kavanaugh to the United States Supreme Court, and I know that since we last were in touch, a lot has happened on that front, so I don't want to get too far off topic. But before we begin, Professor Lindquist, I did want to mention, we were just talking a few moments ago, and Temple Law Review, as we know it, the name Temple Law Review actually came from you and your colleagues on Volume 61. We were previously Temple Law Quarterly. So before we get into the very exciting stuff going on with the Supreme Court, I guess, do you have any thoughts on that or anything you'd like to add to that decision?
Sure. It's been 30 years now. And by the way, thank you so much for the opportunity to participate in this podcast, Andrew. It's been 30 years since I served as editor-in-chief of the Law Review, and it was 30 years ago that we decided to change the name from Temple Law Quarterly to Temple Law Review. And that's because we had aspirations that we would publish more than 4 volumes a year, and we thought the word quarterly would limit us. And also we wanted to be sure that our potential employers outside of Philadelphia knew that we were the Law Review. So yes, we did, and I know it's been 30 years, and I'm very proud of the Law Review and the current the quality of the publication as it stands now. So I hope everyone's happy that it's called the Law Review rather than the Law Quarterly.
Well, I must thank you before we get going, because if you had limited it to a quarterly, we probably wouldn't have an online edition, and I probably wouldn't have a job right now. So thank you for giving me an opportunity to be on the Law Review.
That's great. You're welcome.
So I guess so we'll start off with the very basics. I know when Justice Kennedy announced his retirement, America, in a rather interesting twist, already had a sense of who the next justice might be, given the well-known list developed by the Federal Society and others that President Trump has used in the past. And when it came down to the short list, you had Kavanaugh. I know there was the likes of Thomas Hardiman and the Third Circuit, who some believed was the runner-up when Neil Gorsuch got it, Raymond Kethledge in the Sixth Circuit, and Amy Coney Bryant in the Seventh Circuit. I guess, did anything about this process, as you were kind of looking on as just a average Joe or Jane as everybody else was, did any part of that process, the short list, the ultimate nomination of Kavanaugh, surprise you or strike you as interesting?
Well, I think one of the things that was interesting about the list in general is that it was used during the campaign. It was publicized during the campaign, the longer list that is, in order to provide, I think, conservative voters with the kind of credentials they needed to see from Trump, since at that time President Trump was, not a traditional Republican. And by providing the list of potential candidates to the Supreme Court, nominees to the Supreme Court, he was able to verify for them and certify to them his conservative credentials. So I think that was unusual and atypical for a presidential candidate. In terms of the short list itself, I think that we see a predominance of Catholics on that list, and that's an interesting dynamic, I think, since that may send a signal to pro-life constituencies, that these are justices, potential justices who might ultimately support the reversal and overturning of Roe versus Wade. So that's just an interesting dynamic.
And one of the other, distinguishing characteristics of Judge Kavanaugh's resume was, I know a lot of justices, for instance, will start at a big firm and work their way up from, the appellate divisions. Judge Kavanaugh, his background's in politics. He worked on the Ken Starr investigation. He also served under George W. Bush. Some of his apparent partisanship came out during the hearing last week with Dr. Ford. I guess, and even his circuit court nomination was met with opposition early on due to thoughts that he maybe was too partisan, too political. Do you feel, any way one or the other about his background, whether it's a unique background, whether it's problematic in some ways? Some people might even say it's an asset because he has, a better sense of how the executive branch operates. Does any of that kind of come to mind, or do you have any strong feelings one way or the other?
Well, I think that he, certainly for modern nominees, is a little bit more political than one might typically see. Although, certainly Kagan served in the solicitor's office, and so there's been other nominees and ultimately appointments to the court of individuals who have backgrounds in politics in one way or another. He certainly may be viewed, given his role in the Clinton impeachment, among other things, as secretary to the president, to George Bush, he may have served a more pronounced sort of partisan role in his history. But if we look back over the history of the court, we see that, presidents have appointed individuals who were even heads of federal agencies while they were presidents. And for example, there have been justices who were appointed who were head of the SEC, for example. And that's a very political appointment, although it's an independent agency, but nevertheless it's an appointment that a president would make with politics in mind. So I think we've just become used to appointments that are Court of Appeals judges that are typically a little less political in terms of their personal history than we see with Judge Kavanaugh. But looking over the history of the court, there's certainly plenty of examples of justices who had very prominent political backgrounds who ended up on the court.
Absolutely. And just while you're mentioning that, I just recalled, President Taft eventually became a justice. So that's, I think that's pretty an obvious example. That
there's a perfect example.
Earlier. Yeah, right. Okay. I wish I remember that earlier. Now, after his nomination, there were, very shortly after, there were a number of Democratic senators coming out saying that they would not vote for Kavanaugh. Some have argued, in counter to that this is a spoils system, that there should be a deference to the president in selecting justices. Obviously, those who feel that way now may not have felt that way 2 years ago when President Obama nominated Merrick Garland, who obviously didn't get even a hearing. You look at some of the justices that have recently been on the court. Anthony Kennedy received a 97-0 vote. Ruth Bader Ginsburg, 96-3, Stephen Breyer, 87-9. Do you feel as though, in some way or the other, that deference that some may say, it belongs in this kind of nomination? Do you feel that maybe that's faded in a way?
I definitely think that deference to the president has eroded over time. And if you look back over sort of modern history, you see this developing, obviously, in response to the Bork confirmation hearings that became far more politicized than any confirmation hearings prior to that. But then the back and forth over the filibuster, especially for lower federal court judges, became quite an issue during the Obama presidency, and ultimately the filibuster was eliminated by the Democrats for lower federal court judges. And that then, I think, laid the groundwork for the filibuster, the nuclear option, to be exercised in 2016. And I think the elimination of the filibuster is a reflection of the kind of politicized nature, how politicized the process has become, and that this is now something that is a political choice for the senators rather than a matter of more or less deference to the president. That is, I think in earlier history in the United States, the choice of a Supreme Court justice was considered kind of a perk of the president, and as long as there wasn't any major problems or ethical issues in the nominees past, then the president would have a fairly broad scope of discretion to choose. And that depends of course, upon the president's popularity at the time of the choice and other things as well, but nevertheless there was considerable discretion. But now that has, I think, substantially changed as the process has become more politicized. And for the senators, there is far more at stake in terms of their vote for individual nominees than there ever had been in the past. And that has, of course, then removed that link, or that removed their willingness to, or eliminated their willingness to provide the president with a broad scope of discretion in choosing his or her nominees.
And you just
I should say his nominees, and so far it hasn't been a woman. Yeah.
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 And you just referenced Judge Bork, who I believe was also a D.C. appeals judge when in 1987 when President Reagan nominated him. He was the last. I believe there's been 11 nominations in history to lose at the Senate voting stage. Obviously, there's been a number of others who pulled out or withdrawn prior to a vote. But the last time that happened was Robert Bork. And obviously, as you mentioned, there were some heated discussions about that based off his civil rights record, based off his service under President Nixon. And even in that point, you still had, I guess, 6 of the 46 Republicans that were in the Senate at the time who still voted against him, and 2 of the 54 Democrats voted for him. Flash forward, 30 years, and Neil Gorsuch, every Republican who voted yes last year, and all but 3 Democrats voted no. I guess you said before, just a few moments ago, that maybe senators have more pressure on them in terms of who their voting record on Supreme Court nominations. I guess, do you see this as a more political position now, or maybe is there more pressure on legislative representatives to kind of have a better control over how this happens?
Yeah, I think what we're seeing is this is symptomatic of a larger problem of party polarization in both the Senate and the House, and frankly across most politics in the United States writ large. And there was a time, of course, where there was that members of the Senate and the House voted with their colleagues across the aisle. And that happens very rarely today. For the most part, there is straight party voting and very, very polarized voting. And that is also symptomatic, I think, or reflective of the kind of ideological polarization we see in the electorate, unfortunately. So the academics have documented this very extensively, that there is this polarization, and we're all well aware of it because we live it every day. And I think that the confirmation process is simply also kind of a victim of this kind of polarization, and that the members of the Democratic Party and members of the Republican Party are simply unwilling to vote for the other party's nominee. And I think it's only been exacerbated both by the elimination of the filibuster in the Senate and also by the refusal of the Republicans, of course, to even hold a hearing on Merrick Garland. So now it's become really it's really become a kind of a nuclear war between a political nuclear war, so to speak, and metaphor might be a little bit extreme, but certainly there's a standoff between the two parties here. And that is part of the reason we see it's a confluence of multiple events and circumstances in terms of polarization and in terms of recent historical events where the parties have come nose to nose and neither has been willing to back down.
And do you see that as the reason for that as being, I guess, representatives drawing a line in the sand? Or I know for any kind of any student who's taken the first few weeks of con law, obviously President Adams selecting John Marshall, that had obviously a lot of political oomph to it. So has this always been this way, and now maybe we're more conscious of it because Congress seems more divided now than in years past? Is it abortion rights? I know earlier you're referencing, the Catholic, I guess, movement into the court. Are presidents selecting justices that might have a little more of a pronounced political leaning, or I guess what factors of those do you think are in play, or do you think this is really just kind of senators kind of digging their feet in the ground and saying we're not going to move?
Yeah, I appreciate the reference to Adams and Jefferson, and I think that and Marbury versus Madison. I think that it would be naive to say that the court has never been either involved in kind of political intrigue or been or been viewed as a political body. And I think if you look back at Marbury versus Madison and study the historical context of that decision, you see very much a political power play between Jefferson and Marshall, and Marshall responding very strategically. And in fact, if you look back at the history of that decision and the events surrounding it, you see that the Democrats, the Republicans, I guess they were called the Democratic Republicans at the time, in response to the Federalists, actually threatened. They did impeach one federal judge, Judge Pickering, and they impeached but did not convict, so they did not remove from the bench a Supreme Court justice named Salmon Chase after the Marbury decision was rendered. And so there was even threats of removing federal judges through the impeachment process as a way to try to influence, at least that's the speculation historically by historians and political scientists, is that there was an effort there to influence the outcome of certain cases that were pending before the court, not just Marbury, but also a challenge to the Judiciary Act of a repeal of the Judiciary Act of 1801. So that was a very politicized environment, and the court very much got caught up in that, and Marshall made an extremely wise strategic choice to preserve the institution and to strengthen judicial review. But I think looking back through the decision of Marbury versus Madison, but I think looking back at that context, one sees the court very much involved in politics. And then, of course, if you look at the Lochner era, even the Civil War era, Lincoln for a while was faced with a court that was dominated by Democrats. And so there was conflict between the president and the court in both those circumstances, and the court had to carefully think about its legitimacy and how it was going to respond to the executive branch and how it rendered its decision. So this is, and we had the switch in time that saved 9, in which the Supreme Court, one of the justices switched his vote to start upholding the New Deal in response to FDR's initiative to pack the court and to increase the size of the court to 15 justices. So all of those historical events, I think, indicate and reflect the court as being very much part of American politics. I think what we're seeing now, though, is that politics very much being driven into the nomination and confirmation process itself in a way that I don't think has been seen throughout history, and that is systematically now part of the process. And in fact, even if you just look back at, it's become very much pronounced in recent years. If you look back even at the Thomas confirmation hearings, which were very controversial, obviously, if you look back at those, there was a substantial proportion of the American population that really had not even formed a view at the time about whether Thomas should be confirmed or not. In fact, there was a substantial portion of the population, when asked in an opinion poll who was telling the truth, they hadn't even formed an opinion about who was telling the truth, whether it was Anita Hill or Clarence Thomas. And that's because it wasn't as salient, I guess, and I guess the public wasn't paying as much attention. I think now, if you asked, the opinion poll was, and I know there have been some, very few people haven't formed an opinion. So I think that reflects the notion that Supreme Court confirmation hearings have become highly salient political events, and much more so than they've ever been in the history of the United States, even though the court itself has been embroiled in some political, controversies over the course of its history.
And just a brief follow-up on that, you mentioned that obviously the court in some ways has been political from the beginning, but you mentioned maybe this wasn't an issue as much 10, 15, 20 years ago because people weren't paying attention as much. I guess, do you feel as though that might be social media, that might be the 24-hour news cycle? Do you feel as though people are forming opinions because they, even if they're just kind of sitting on Twitter all day, they're consuming information and forming opinions that way? Has that changed things at all, do you think?
I do, and I think that's clearly a major part of it. Twitter is, and all the social media outlets that we have, means that everyone is getting the information in real time. And also, I think it's just a result of the fact that everything is now a political fight in ways that it wasn't necessarily even in the recent past quite as much. But we have such a highly polarized electorate now. That everything is now down to a fight, and if you turn on the television, there's no more Walter Cronkite's, right? For the most part, we have we have very, very politicized, or in some ways, very politicized news outlets. Not all of them, and I certainly don't. I'm very, very supportive of the news and media industry and reporters. But nevertheless, you can certainly pick what news reporting you want to watch, and sometimes those reporters will play to a particular orientation, ideological orientation in their viewership, and so the whole thing has created a much more polarized and, I think, focused attention of people on winning at all costs for their particular faction.
And you mentioned earlier, I guess, your observations in terms of, the president being sometimes at odds with the Supreme Court, and I guess how in recent years you've had situations where the president's kind of has his hands tied if he doesn't have, enough support in Congress. Today we have a situation where, and I know absent some additional damning information that might be come out in the next few days with the FBI investigation, you have an estimated 95 senators who are going to vote along party lines pretty much no matter what with this Kavanaugh nomination. And then there's 5 potential wild cards, 2 on the Democratic side, 3 on the Republican side. In light of recent years, and obviously, appreciative again that these are serious allegations going on. Do you foresee a scenario in which, in practice, maybe not in law, but in practice, a president needs to have a Senate majority in his party, his or her party? I know you said the same thing earlier. In his or her party, during a non-election year to put a justice on the court? Is it going to be that kind of gridlock, difficult to get a judge appointed?
I've thought about that many times, and I think your question is spot on. I've been very concerned that is what the direction and the ultimate result that we're going to see from this polarized nomination and confirmation process. I've wondered whether or not it would be ultimately, that the president would definitely have to have a Senate dominated by his or her own party for him or her to get a nominee through. And I think we're seeing that now with a Senate that probably had most of the senators probably had made up their mind even before Christine Blasey Ford was interviewed. And so it's deeply troubling because the court, here's where I'm concerned about the entire politicization of the process, is that it is essential for the rule of law that the electorate view the courts as objective arbiters of legal disputes without any kind of political bias. And if the court, especially the highest court in the land, and maybe that's an exception, maybe we can say there's an exception there, but nevertheless, if the public starts seeing courts as politically biased, then they won't trust them to make objective decisions. And then you start seeing an erosion of the rule of law. So this could be, the opening of the door to a real problem in our country when it comes to public faith and trust in the court system.
And I've tried not to, again, make too much mention of the allegations of sexual assault against Judge Kavanaugh, as again, I appreciate we might learn more in the coming days. But, like many people, I watched the hearings with he and Dr. Ford. And as you mentioned earlier, some people kind of knew what they were going to, how that felt, and that kind of whole process, reaffirmed their previous position. Maybe some people thought it was a kind of game-changing day or two. But the following day, on that Friday, Senator Flake from your home state surprised some by requesting a brief FBI investigation. I believe that was in coordination with Senator Coons in Delaware. I guess, did that surprise you at all? And I guess for those of us who might not remember, I know you were a young attorney at the time. Do you see any parallels between what we're watching unfold here and what happened with Justice Thomas? I know you mentioned earlier, maybe public knowledge of what was going on might have been different, but do you see any parallels or stark differences?
Well, I mean, there's certainly parallels in the sense that we're dealing with a situation in which a nominee has been accused of sexual harassment, in this case, sexual assault. And so there are certainly parallels there. And the interesting thing, a couple things I want to say about the people's perceptions of the events is that at the time that Thomas was, during that confirmation process, I took a look back at the polls, and apparently at that time, more people believed Thomas than Hill. In fact, it was 28% at the time of, I guess, right at the conclusion of the hearings or soon after the hearings were held. 28% of the electorates believed Thomas, 11% believed Anita Hill, and the rest were not sure or thought that there was maybe some truth coming from both sides. So there was some polarization, but it wasn't extreme. If you look now, I think you see some more extreme polarization. And by the way, one of the interesting dynamics of that particular confirmation process was that the African American community was very strongly in favor of Justice Thomas, and polls demonstrated that. And so that may have had an influence on the senators as well. Now, if you look at the polls, you see, with the exception of some independents, you see that Democrats and Republicans very much view the justice and these allegations in a wholly different light, with Democrats far more likely, obviously, to believe the allegations against Judge Kavanaugh, and the Republicans, and including female Republicans, far more likely to believe Judge Kavanaugh. And I think this is in part reflects some what we call and what psychologists call motivated reasoning, that as you take in evidence, often people will view that evidence through the lens of their own particular preferences. And that may be what's happening here. That may have happened also in the Hill Thomas in that particular conflict there, but it's certainly, I think, happening here. So what you're seeing, or what people see in those testimonies, are things that they expect to see or looking to see, and they're finding confirmation of their particular bias in the testimony of either one. So yes, there are parallels. There's a difference, obviously, in the racial dimension in the Thomas confirmation hearings, but I think we're seeing more polarization in the Kavanaugh hearings, ideological and party polarization.
And along those lines, I guess one of the topics that came up just watching the hearings last week, I guess what the Senate Judiciary Committee's, I guess their duty of advice and consent, and whether or not the allegations against Judge Kavanaugh should be treated as a red flag on a job interview, as anyone else would. Hey, someone's saying this about you. Do we want to hire you for a job that might obviously is going to be public facing, or whether, I guess, a greater amount of corroborating proof is necessary to do anything. I guess, do you come down on one way or the other in terms of the extent or perhaps the limits of the committee's role here? And I guess there seems to be a significant divide in terms of people who think that this is a job interview, and some people who think that this needs, you're almost treating this as a criminal prosecution. I guess, do you kind of fall one way or the other? Do you see both sides?
Well, it's interesting. The advice and consent role applies both to judges and to executive positions in the cabinet and in the executive branch, nominations from the president. But those are not lifetime appointments, and the judiciary, of course, on Supreme Court and federal judiciary, these are lifetime appointments. So I think in some ways, when you think about the advice and consent role, you do have to think about, and in fact, Kavanaugh himself has written about this in one of his articles. I do think you have to think about the consequences of a choice, and that when it comes to a judicial appointment, the Senate's advice and consent role may be even more pronounced in terms of the importance that how important it is that it be probative of the character of the nominee. So that, I think there's something to be said there in terms of how that advice and consent role might vary depending upon the appointment being considered. In addition, I think you can look back at the Senate's history, and the Senate has been voting down, judicial confirmations or judicial appointments or nominations since 1795. I mean, there was a Justice John Rutledge who was rejected as a nominee to the Supreme Court after Washington nominated him for that position. And so this is not a modern phenomenon where the Senate has decided that a particular nominee is not suitable for the court. So this is nothing new. And in fact, it's not really even, obviously the Constitution simply says advice and consent. So how the Senate chooses to exercise that role is really the Senate's decision. I think the Supreme Court views that as a political question that is up to the Senate to decide. And that can vary depending upon historical context and the individuals who are seated in the Senate.
And
in other words,
finally,
I don't think there's a right answer to your question. I think it depends.
I come up on that side of things a lot, unfortunately. And finally, and perhaps some would argue most importantly, I do want to get to some law here, and there is some obvious interest in Judge Kavanaugh's views on a variety of issues. Obviously, he had that article that some people say is more of a policy position than a constitutional law position in terms of the executive power. I know he wrote that article in the University of Minnesota's Law Review about 6 or 7 or 8 years ago, and how that kind of plays into the Mueller investigation. Obviously, as you mentioned very early on, opponents of confirming Kavanaugh from the beginning have pointed toward preserving Roe and Casey as reasons for keeping them off the bench. Are there any issues that you see that come to mind that you believe that the Supreme Court and whoever the new justice might be, obviously Judge Kavanaugh being the leading contender, will kind of have to deal with in the next year or two, that people that, whoever ends up being on the court, you're keeping an eye on and you're interested in seeing how the court treats this particular issue?
Well, yeah, I mean, I think the question of presidential power is very likely to come before this court in some manifestation. There is an emoluments clause case that is moving forward in the lower courts, and so it's against President Trump, so it's possible that particular case might end up at the court, among others. And so I do think that the question of presidential power is likely to come before the court, and that is something I think that the senators who were questioning Judge Kavanaugh were very interested in finding out his particular perspective. I've read his Law Review article, and he makes the point that I think probably as a result of his sitting at President Bush's elbow for so long in his role in the White House, that he's concerned about the president being able to manage the incredible burdens of the office while simultaneously dealing with a lawsuit or an indictment for that matter. And so that's the way he expresses his concern about protecting or insulating a president from legal lawsuits until after the presidency is concluded. And so I think, that expression of that particular perspective might give us certainly some insights into how he might address cases that come before the court, assuming he does not recuse. And the question is, under what circumstances would he have to do that? Or should he do that, I should say. So yes, I do think as far as Roe and Casey are concerned, that is a perennial concern. You mentioned the abortion cases and Roe versus Wade precedent in a previous question that you asked me, and there's no question, I think, that is a real flashpoint in American politics. I've written a book about judicial activism, and I think that those people who criticize activism view Roe versus Wade as the real poster child for a kind of case that is extremely activist. And so that's been the conservative stance on the case, and I think it's likely that if a case came before the Supreme Court, a future Justice Kavanaugh would be hard-pressed to read abortion precedents in an expansive way to expand the right. I think he'd be more likely to restrict the right. Whether he'd overrule Roe versus Wade or vote to overrule Roe versus Wade is open to question. But at the very least, presidential power and abortion rights are going to be flashpoints going forward, and his record suggests that he might take a very expansive view of presidential power and not a very expansive role on abortion rights.
Keeping on Roe and Casey real quick, I guess, do you feel as though, one conservative viewpoint is that this is judicial activism and the Constitution doesn't say that this should be allowed. On the other hand, this has been the law of the land for several decades. Do you feel as though, that's enough, that kind of precedent is enough to protect it the way people want to protect it? Or do you feel as though, it's kind of free reign for whoever kind of takes it to court next?
Yeah, I've always, I think it's stare decisis. One of the kind of policy justifications for that norm in the court is predictability and stability in the law. And where citizens are organizing their financial or other affairs around precedent, you want to make sure it's not being constantly reversed. But we do see the Supreme Court reversing precedent even after a long period of time. The most obvious example, and a good one, of course, in terms of the policy outcome, is Brown versus Board of Education,
Sure.
which in 1953 reversed the precedent that was enunciated in 1896. So that's quite a long period of time in which that precedent was on the books, but ultimately the court chose to overturn it. And so I don't think that it's inconceivable that Roe versus Wade would be overturned. And it's really just how, and frankly, I think most people in the United States realize that even though Roe versus Wade is on the books, it does not mean that abortion services are readily available for women around the country. In fact, they're not. In many states, there are very few abortion clinics left operating as a result of other kinds of state restrictions that have been imposed and that have been upheld by the Supreme Court. So the precedent has been limited in so many ways that overturning it, I'm not sure it would be changing people's perceptions of their rights all that much, particularly in states where abortion clinics are no longer operating. And I actually think this is I think it is vulnerable to overruling, and I don't think that the fact that it's been on the books for a very long time necessarily insulates it from being overruled.
And finally, I guess as we have with our first few podcasts, I'd like to wrap up with a catch-all question. I'm sure that our listeners, like many people, certainly like myself, have been talking about Brett Kavanaugh and this whole nomination process at work, with family, at the local watering hole. And from, I guess, your background, and I'm so happy to speaking with you because you have a background both in law and political science. I guess when you kind of talk about this with family or friends, or when you're just thinking about this yourself, I guess what are one or two things that kind of catch your eye that are interesting to you on this subject that might be, for the lack of a better word, fun or nice for reasonable minds to kind of talk about and debate and kind of share their thoughts or that sort of thing? Is there anything that kind of
Sure.
Jumps to mind?
Yeah, I think what we're facing, and I think this is definitely worthy of conversations around the watering hole, so to speak, as you mentioned, is the legitimacy of the court and the consequences for the court and for, frankly, for American democracy if the court becomes a very highly politicized body where the electorate views the justices on the bench sitting on the court as no more than politicians in robes, which is a common term that's used, a phrase that's used to describe activist judges sometimes. And I think it is important for us to bear in mind that the judiciary's legitimacy is not a given. Now, it is true that the Supreme Court over time has had higher public opinion or perception. The public perceives it as a stronger or more kind of what's the word I'm looking for? Legitimate institution than Congress and the presidency sometimes. And Congress often has very low ratings in public opinion polls. But the legitimacy of the court is definitely not a given. And when we think about the court, there's a reason why the justices and judges wear black robes and sit on a dais. And the idea is that they are somehow separated from politics. Their humanity is shielded, so to speak, by a robe. And in England, of course, the judges wear wigs even to hide their heads and make them look very uniform. It's a way to remove the human bias and to suggest that there's something here that has been elevated above human bias and decision making, so that we have individuals who are highly objective. So when we think about the court, we want to make sure, and especially the U.S. Supreme Court, that the public's perception of its legitimacy continues. Otherwise, as I mentioned previously, we might experience an erosion of the rule of law. And the rule of law is a fundamental principle of democracy. Democracy simply cannot survive without people's perception that the law is fairly applied, that they can count on certain legal outcomes, that the courts will be unbiased and they evaluate individual cases before them. And without that, the whole system will start to erode. So I think what we're seeing here in the Cavanagh confirmation process, as well as other recent confirmations of Supreme Court justices and even of Court of Appeals and District Court judges, is a politicization of the process that might change the public's perception of whether judges are objective. And once that happens, people will stop bringing their disputes to a court to be resolved. And yet you really want to think hard about the consequences of what that means down the road, with people instead resolving their disputes in other ways that could lead to violence and other consequences. So just thinking long term and at the 30,000 foot level, I do think we need to think about what are the consequences of these current events for the court's legitimacy, and bear in mind its consequences for the rule of law.
Excellent. Well, Professor Lindquist, thank you so much. This is an excellent conversation, and I'm sure that some of our listeners right now are Google imaging what English judges look like, and their dress and wigs and whatnot. But it was an absolute pleasure speaking with you. Thanks for the name, and thanks for taking some time today. I really do appreciate it.
Well, Andrew, thank you so much. It's been a pleasure to reconnect with Temple Law Review and with you, and I very, very much value what you're doing, and I hope this will be helpful to your listeners in some way, shape, or form. So thanks a lot.